this morning, we are joined by the chairman of the Independent Judicial Accountability Panel, His Lordship, Honorable Justice Mojeed Owoade, who is a retired justice of the Court of Appeal. He joins us virtually from Ibadan. Good morning, Your Lordship. Thank you so much for speaking with us this morning. Very important work that your panel has undertaken in this regard. May I ask you, how did the cases which you set up for review come to be the ones that you reviewed in the first instance?
Thank you very much. We try to examine cases that are of public interest. You recall that IJAP arose from Cliff Justice Program of Action Aid. And Action Aid is a poor non-governmental organization. And therefore, those things that would interest the general public, especially the masses, we tend to examine, study them, and make appropriate recommendations or suggestions, as the case may be. This is the position of things. Okay,
very interesting cases that you have decided to take on and look at. Some of them were a bit controversial in their time. Take, for instance, this issue of the placeholder matter. I mean, that's how the public will remember this particular case, which eventually went to court. Case. Yes, which eventually went up to the Supreme Court. Today, Senator Ahmed Lawan is sitting in the Senate, and Manchina is nowhere to be found, even though, well, he pursued his matter. From what I can see here, you do not seem to, I wouldn't say you don't agree with the Supreme Court, but you recommend that the Supreme Court ought to have taken a look at the substantive matter rather than rest on technicalities. Is that correct?
Well, we believe that the matter that came before the Supreme Court itself was decided on technicalities rather than substantial justice, as they used to do. Supreme Court itself has laid it down that cases must follow substantial justice. But in the Lawan or the Machina case, as people tend to call it, the Supreme Court unfortunately espoused technical justice rather than substantial justice. And that was, so we now reminded the Supreme Court that in future, please try and stay with your recommendation, suggestion that we should try and do substantial cases as substantial justice as much as possible. That is the difference. But you may not have enough time for us to go into the details, because they were talking about that the case should have been instituted by way of writ of summons rather than originating summons. But there was nothing that would have stopped Machina from actually instituting the case by way of originating summons, as he did. And recall that in the particular case, the Supreme Court itself was 3-2. So two of the justices felt no, the case was properly instituted and it will have been taken on its merits, which was not so by virtue of the ruling of the majority. So that was why we now said no. In future, stick to your admonition on substantial justice rather than technical justice. Thank you.
I'm taking a look at this second matter, which you also highlighted, well, which is in the matter Oyetola versus INEC. What exactly was this case about? You say this, I mean, part of what you said was that you pick your cases based on public interest. Was this also controversial at the time?
No. What happened in the Oyetola case, that was the Osun governorship case. INEC declared Adeleke as winner, and he now went to the Court of Appeal. The Court of Appeal and the Supreme Court did the proper things, but gave us proper education as to what exactly a petitioner must prove to be successful in election matters. So this was pressing, as it were, pressing the Supreme Court on what they did in the Oyetola and the Rose Bible cases. We are saying that this was a good path, which should also be followed in the future. We did not say the Supreme Court was wrong. If anybody was wrong in the Oyetola case, it was the tribunal that did not get the principles of law right. But the Court of Appeal and the Supreme Court corrected that situation and showed us the importance of beavers improving election petitions or election matters. In other words, you cannot say that a person who did not tender beavers, for example, who did not tender register of voters, is the person who won an election, as was done by the tribunal in the Oyetola case. This was corrected by the Court of Appeal and upheld by the Supreme Court. So we don't want to always criticize the Supreme Court. We feel that when they have done very well, we should also be able to announce that, as it were, to the public.
So on this particular matter, you found that they did well?
Yes, thank you very much. That's the way to put it. They did well. They did well in Oyetola case. They did very well in the Rose Bible case. Okay. That's exactly what.
Part of what I also notice here is that you talk about constitutional bills and the electoral bill, which I'll come to shortly. But I want to take you up on the issue of the emergency declaration in Rivers, which was before a court. From what we understand, that matter has now been thrown out by a court. I think it was on Friday that news came through, that the matter has now been thrown out by the court. Do you have that news? I had the news. That was one high court, but the matter is still pending before the Supreme Court. Our comment on that is that in such important constitutional matters, the Supreme Court should not delay the cause of public interest. That the Supreme Court should have had this case a long time ago. So we are talking about the matter before the Supreme Court, not the one that was thrown out before the High Court, before one of the High Courts, perhaps the Federal High Court. So it's the Supreme Court. We commented that the Supreme Court should not delay in hearing important constitutional matters, such as the one before it on the Rivers matter. Thank you. Not the one that was thrown out. Will it still, because now the emergency rule is over, from what we know, the governor is back in office. If the Supreme Court were to sit on this matter, would it still have any relevance or any bearing?
It will. It will have bearing. It will have bearing because it will still create precedence on the interpretation of the emergency powers of presidents under Section 305 of the Constitution. So it will definitely have bearing. So they can still decide it. Nothing stops them.
All right.
Yes.
You are a retired Justice of the Court of Appeal. Are you aware of anything that could be, could have caused an impediment as to why the Supreme Court might not have heard this matter up till now?
Well, there could be impediments in terms of the workload of cases of the docket. You say, but exactly that's why we came in. Whatever the docket, when there are important constitutional matters of national importance, they should be given preference so that people will be guided. That is what we are saying. That is what we are doing. Yes, there could be impediments, no doubt, but we are saying that in future, such impediments should give way for the importance of such cases, because the members of the public were actually waiting to hear from the Supreme Court. People could not comment on the case because it was before the Supreme Court. The question is, the Supreme Court should now tell us what is the position of things when it comes that way. Can the president, for example, do this and do that under Section 305? So it is still relevant in terms of precedence. That is our contribution.
One of the things I noted here about the emergency rule in Rivers State is that you say the National Assembly adopted a voice vote as against a roll call vote to establish the two-thirds majority of its members required by Section 305 of the Constitution on such an important issue. You go on to recommend that on important constitutional cases or issues, the National Assembly should use a roll call vote to establish the required majority instead of a voice vote. Is this a matter that can be challenged in court?
Well, it can be challenged. No, there's no doubt about that. It can be challenged because it was a constitutional stipulation. When there is a constitutional stipulation, you cannot adopt a voice vote. Because people should be able to know how did you get to 2/3 in terms of Section 305, or in some cases, maybe 4/5 when there's amendment to the Constitution. I think they should, in all cases, have a roll call vote and not a voice vote. Thank you.
All right. A number of other issues, but I'm sure that my colleague Ayo would like to take you up on them. Ayo, over to you.
Okay.
Thank you. Thank you.
You know, one of the things that's bothered my mind about this particular issue that we've been talking about is the place of not just the judges now, but the lawyers that come before the judges. From your experience as an experienced jurist and the things that you have had to encounter from legal practitioners as well, what is your reading of how some of those cases are brought and argued that could have brought the judiciary to the state where it is today?
I hope I understood.
Can you hear me, sir?
Yeah. You mean the attitude of lawyers?
Yes, that could have degraded the situation to where you and your team have to be intervening the way you are right now.
Yes. Unfortunately, it is not in all cases that lawyers think of public interest. The average lawyer thinks of winning his case or her case, as the case may be. And of course, that's problematic. Lawyers should help the courts. They are not always helping the courts. I think it's safer to put it that way. The role of a lawyer is to help the courts, but almost invariably, they are not always playing that role properly. I think that is because it is not the case. In many cases, the opposing lawyer knows what is right. The defending lawyer may know what is right, but they will present that which will favor the points or the case that they are pursuing, so to say. I hope I do get your point here.
Actually, you do, but you know, still speaking in the same light, it means then, from what you're saying, that if the lawyers are not helping the court, they want to win a case so that at least that kind of increases their marketability, if I can put it that way, and all of that. So if the lawyers are not thinking of overriding public interest in winning cases, in arguing before the courts, then I don't know.
Even
it would
seem like the cases.
Go ahead, sir.
Yeah. I say even in bringing the cases, some of the cases probably will not have been brought to court. Some of the cases that the lawyer will have considered one way or the other, but they hardly get to do that. So that's repeating what I've said. Yes. But you also, are going to say something.
Yes, perhaps that also raises the issue of whether there is a role for the NBA or for the National Judicial Council on that to ensure that there is focus on what the nation needs and not just what one or two interests need in any case.
Well, let's put it this way. The business of lawyering is different from the business of adjudication, even though they cross the line or they arose from the same source, so to say. I mean, the lawyer will be a lawyer, the judge will be the judge. And that's why we have them in different capacities. See, we cannot put it too much on them that they have to argue at all times in terms of public interest. No, in fact, public interest itself requires definitions. So let us just put it that, well, when there is the business of lawyering, there is the business of adjudication, where the business of adjudication becomes more important because the consequences affect public interest. That is the way to put it.
Okay.
Exactly.
But now, speaking in that same light, there is a pile of cases that dates back many decades, many years.
No doubt.
Some of those people who brought those cases to courts have died. some situations have overridden some of the reasons for which those cases were brought to court. Are the issues you have raised this morning, how do they come in that kind of light? Because if there is a focus for what the purpose of lawyering and adjudicating thing should be, will we have so many cases, or are there some other issues that occasion that we are not aware of?
Definitely, if that purpose is fulfilled, we will not have as many cases as we are having. Definitely, because there are many cases that wouldn't have been in the courts in the first instance. There is no doubt about that. But when they are now in the courts, it becomes the business of the adjudicator to clear the cases. The courts are constantly battling with the problems of delay in handling cases. And I know I can speak, for example, for the Court of Appeal, and indeed the Supreme Court. They are trying all possible ways to clear those cases because there are rather too many. As far in between the Court of Appeal and the Supreme Court, some of the things to do, or even the High Court, is to reduce the types of cases that will go to particular courts or that will go on appeal to particular courts. I hope you understand what I'm saying. In other words, we can say at the High Court level, these cases should stop at Magistrate Court. These cases should stop at High Court. These cases should stop at Court of Appeal. Some of these cases should never get to the Supreme Court. In that way, therefore, there will be, for example, you recall, one of the justices of the Supreme Court, when she retired, Justice Amina Agi, she said, unfortunately, the Supreme Court still battles with even cases of people that steal goods, quote and unquote. In other words, trivial matters should not get up to that stage. Some should not even get to the Court of Appeal. That would be one of the best ways of reducing congestion in the courts. Thank you. Okay.
I think the question now for me is now, where exactly would these recommendations be used? I mean, how do you intend to push these recommendations forward?
God, Malpe, some of our previous recommendations have been adopted by coincidence because some others could have pressurized the National Assembly in this direction also. But if you look, what you are going to say, constitutional bills, we have a list of suggestions, recommendations that we made that have now been adopted by the Constitutional Review Committee on constitutional bills. One of them is about pre-election, appointment of INEC chairman, and so on and so forth. So we go to visit the National Assembly, give them our papers, so that, because the legislature actually is the best point for law reform. So if you look at that paper, you find out that some of our recommendations have now been included in the pending attempts to review the Constitution, to review the Electoral Act, and so on. And we have been able to identify them.
How very upbeat are you that this constitutional amendment process is going to yield the, will I say, the changes that Nigeria desire to see, not just in the judicial system, but also in the executive and legislative arm of governments? Because there are those who have lost faith in this constitutional amendment process and who are asking for a new constitution altogether.
Well, the starting point is the constitutional provisions will not solve all problems in society. A new constitution, yes, those are people that are concerned with the fundamentals, the way that the constitution is brought about to be. So you cannot blame them for looking for an entirely new constitution. But in terms of assessing executive behavior, judicial behavior, legislative behavior, the amendments will still go a long way to solve our problems, if I can put it that way. Yes. There are two different things. Amendments take one portion, which will still regulate behavior, but those that are concerned with another constitution. They are talking about the fundamentals, the way the constitution is brought about, the constituents of the nation. Of course, you know. So that either way, the amendments will go a long way, but perhaps having a new constitution will be a better representation of the problems of the diverse nations of Nigeria. I think I'll stop there. Diverse nations, exactly.
We have to thank you very much for sharing your thoughts with us, Justice Owoade. We have to wrap it up at this particular point. We sincerely hope that the changes which you have recommended eventually make their way into our constitutional review outcomes. We've been speaking with Honorable Justice Mojeed Owoade, retired Justice of the Court of Appeal, who is the chairman of the Independent Judicial Accountability Panel. He joined us virtually from Ibadan. Thank you so much, sir.
Thank you. Thank you for having me. Thank you.